At R.V. Morris from 2021 from the Foundations of Law NCA syllabus for the summer of 2022. The issue in this particular case is, was the sentence given unfit due to the trial judge's application of the impact of anti-black racism as a mitigation for the crime? So the background on this case was, this is an appeal by the Crown, appealing a sentence of 15 months imprisonment and 18 months probation for offenses related to the respondent's possession of a loaded handgun. Police located the handgun in his jacket after he fled from police and discarded his jacket. The respondent, a black male, was 23 when he committed these offenses. He had no criminal record at the time of sentencing. As a result of a stabbing in 2013, the respondent had ongoing medical problems that also affected his mental health. The trial judge acknowledged that deterrence and denunciation were the most important objectives, and they required a significant jail term, but that systemic racism effectively limited the choices available to the respondent, so that the general deterrence and denunciation should have a less significant role in sentencing. Basically, the trial judge gave a light sentence by weighing in systemic racism against the actual negative effects of the crime itself. And the Crown here is arguing that the sentence was unfit, and that the trial judge made several material errors in his reasoning, particularly in his treatment of the evidence led by the respondent concerning the impact of the overt and institutional anti-black racism. So the main rule that is really coming from this particular case is that the gravity or seriousness of an offense is determined by its normative wrongfulness and the harm posed or caused by that conduct in the circumstances in which the conduct occurred. Accordingly, unlike when assessing the offender's degree of personal responsibility, an offender's experience with anti-black racism does not impact on the seriousness or gravity of the offense. That is the rule we can take away from this case here. So the analysis that led to this, basically, in summary, social context, evidence related to the offender's life experiences may be used, where relevant, to mitigate the offender's degree of responsibility for the offense and/or to assist in the blending of the principles and objectives of sentencing to achieve a sentence which best serves the purposes of sentencing as described in Section 718. And the gravity or seriousness of an offense is determined by its normative wrongfulness and the harm posed or caused by that conduct in the circumstances in which the conduct occurred. Accordingly, unlike when assessing the offender's degree of personal responsibility, an offender's experience with anti-black racism does not impact on the serious or gravity of the offense. So the conclusion here, the trial judge was held to have erred in holding that systemic racism and its impact on the respondent could mitigate the seriousness of the offenses committed by him and thereby reduce the significance of the objectives of denunciation and general deterrence and the fixing of an appropriate sentence. Basically, they're saying the trial judge went too light in the sentencing, and they go on to say the sentence imposed for possession of the handgun was far below the range, and the trial judge did not consider whether his failure to take any responsibility, the respondent's failure, for his criminal conduct rendered a lenient sentence inappropriate in the circumstances. So, the possession of a loaded, concealed handgun in a public place, the flight from the police, the disposal of the loaded weapon in a public place, all of these are aggravating factors. The appellant was a young first offender at the time of sentencing. Mitigating factors. His moral blameworthiness was mitigated by his mental and physical health issues, as well as his educational and economic disadvantages personal to him. These mitigating factors are personal to him. So all of these factors were influenced by the systemic anti-black racism the respondent had experienced, but these were the factors that the court is saying to take as mitigation against those aggravating factors. So some of the Section 718 sentencing factors that we're going to look at here, we'll start with proportionality. So the issue here was whether the sentence is proportionate to the gravity of the offense and the degree of responsibility of the offender. Here are some of the rules that apply. The sentencing judge must determine a fit sentence governed by the fundamental tenets of criminal responsibility, including free will, and the purposes, principles, and objectives of sentencing laid down in Part 23 of the Criminal Code. And this is coming from R.V. Morris, directly from R.V. Morris. Okay. R.V. Hamilton, 2004. These cases acknowledge that an offender's personal circumstances, including those tied to overt and institutional racism and its multifaceted effects, can be relevant in determining an appropriate sentence. Next rule, proportionality is the fundamental and overarching principle of sentencing. The other sentencing principles set out in Section 718(2) must be taken into account and blended in a manner which produces a sentence that is proportionate to the gravity of the offense and the degree of responsibility of the offender. A sentence which does not comply with the proportionality principle is an unfit sentence. That's coming from the Ipele case. Next rule. An assessment of the gravity or seriousness of the offense is one part of the proportionality analysis. The seriousness of the offense is reflected in the essential elements of the offense. The more blameworthy the required mens rea, and the more harmful the prohibited conduct, the more serious the crime. The gravity of the offense is also reflected in the applicable penalty provision. In addition, the specific circumstances surrounding the commission of the offense can make the crime more or less serious. Parliament has identified some of the features which aggravate the seriousness of an offense in Section 718(2)(a) from the Hamilton case and from the Ipele case. As described in Friesen, the gravity of an offense takes into account the normative wrongfulness of the conduct and the harm posed or caused by the conduct. Next two rules come from this case too, or at least are summarized in this case, and it is important to preserve the distinction between factors relevant to the seriousness or gravity of the crime on the one hand, and the factors relevant to the offender's degree of responsibility on the other. Unless the distinction between those two is maintained, the proportionality principle may be misapplied. A sentence like the sentence imposed here, which wrongly discounts the seriousness of the offense to reflect factors which are actually relevant to the offender's degree of responsibility, will almost inevitably produce a sentence that does not adequately reflect the seriousness of the offense, and therefore fails to achieve the requisite proportionality. And finally, as long as the sentence imposed complies with the proportionality requirements in Section 718(1), trial judges are given considerable discretion to decide how best to blend the various legitimate objectives of sentencing. If trial judges operate within that band of discretion, the different weight assigned to different objectives may produce different, but nonetheless equally fit sentences. Okay, some of the analysis that was applied here by the court. Nothing in the social context evidence adduced on Mr. Morse's behalf detracted from the seriousness of his crimes or the need to denounce that criminal conduct and deter others from committing similar crimes. Mr. Morse's own experiences in the community, as related to Mrs. Sibilis, strongly make the case for the very real and deep harm caused to everyone in the community by persons who, like Mr. Morse, chose to engage in dangerous criminal conduct that inevitably compromises the security of the entire community. They go on to say that the social context evidence can, however, provide a basis upon which a trial judge concludes that the fundamental purpose of sentencing, as outlined in Section 718, is better served by a sentence that, while recognizing the seriousness of the offense, gives less weight to the specific deterrence of the offender and greater weight to the rehabilitation of the offender through a sentence that addresses the societal disadvantages caused to the offender by factors such as systemic racism. If society's complicity in institutional racism means denunciation and general deterrence should play a lesser role in sentencing for serious crimes, it will follow that black offenders who commit these serious crimes, such as gun crimes, will receive shorter jail sentences than other similarly situated non-black offenders. We strongly doubt, says the court, that more lenient sentences for the perpetrators of gun crimes will be seen by the law-abiding members of the community as a positive step towards social equality. Any failure to unequivocally and firmly denounce serious gun crimes, like those committed by Mr. Morris, through the punishment imposed, implies tolerance of these crimes when committed by certain offenders in certain communities. The court continues, although we reject the claim that societal complicity in anti-black racism diminishes the need to denounce and deter serious criminal conduct, we accept wholeheartedly that sentencing judges must acknowledge societal complicity in systemic racism and be alert to the possibility that the sentencing process itself may foster that complicity. A frank acknowledgement of the existence of and harm caused by systemic anti-black racism, combined with a careful consideration of the kind of evidence adduced in this case, will go some distance toward disassociating the sentencing process from society's complicity in anti-black racism. And the court goes on to say, well, we do not agree that evidence of the impact of anti-black racism on an offender can diminish the seriousness of the offense, or that systemic inequalities diminish the court's authority, or indeed its obligation to denounce serious criminal conduct. We do accept that evidence of anti-black racism and its impact on the specific offender can be an important consideration when determining the appropriate sentence. It was open to the trial judge in the original case to find that the evidence of anti-black racism was connected to or played a role in Mr. Morris's strong fear for his personal safety in the community. That state of mind offered a mitigating explanation for Mr. Morris's possession of the loaded concealed handgun. Looking at it in this way, evidence of anti-black racism, which played a role in generating the fear that helps explain why Mr. Morris had a loaded gun, is akin, for the purposes of sentencing, to evidence that Mr. Morris had been terrorized by somebody in the community and had armed himself because he genuinely feared that person. Personal mitigating circumstance. In either scenario, the offender offers an explanation for possessing a loaded gun, which to some extent ameliorates the offender's moral responsibility for that choice. It must be stressed, however, that Mr. Morris's genuine fear, regardless of its cause, is only a limited mitigating factor. He still chose to arm himself in public with a concealed, loaded, deadly weapon. As indicated above, Mr. Morris's reasons for choosing to arm himself do not detract from the seriousness of the crime he committed, even if his conduct is made somewhat less blameworthy by the explanation offered for possessing the loaded handgun. Mr. Morris's conduct still put members of the community and police officers engaged in the lawful execution of their duties at real risk. Evidence about an offender's background and circumstances allows the sentencing judge to more accurately assess how sometimes competing objectives of sentencing, such as rehab and denunciation, can best be blended to produce a sentence that accords with the proportionality principle and serves the fundamental purpose of sentencing that is articulated in Section 718. In summary, concludes the court, social context evidence, which helps explain how the offender came to commit the offense, or which allows for a more informed and accurate assessment of the offender's background, character, and potential when choosing from among available sanctions, is relevant and admissible on sentencing. Acknowledging the reality of anti-black racism and its impact on offenders like Mr. Morris during the sentencing process enhances the legitimacy of the criminal justice system in the eyes of the community, and in particular, those in the community who have good reason to see the criminal justice system as racist and unjust. A sentencing process which frankly acknowledges and addresses the realities of the offender's life takes one important step towards the goal of equal justice for all. Okay, going on to the parity principle in Section 718.2. requires that to the extent offenders and their offenses are similar, those sentences should be similar. So parity aims at substantive equality. If there are material differences between the circumstances of the offense or the offender, those differences must be reflected in the sentences imposed. But a sentence which takes those differences into account does not offend the parity principle, instead properly recognizes the relationship between that principle and the fundamental principle of proportionality from the Friesen case. The analysis here was the fitness of Mr. Morris's sentence does not ultimately depend on a comparison of that sentence with those imposed in other gun crime cases. The fitness of the sentence turns on whether the trial judge erred in holding that the social context evidence both diminished the seriousness of the offenses and mitigated Mr. Morris's personal responsibility to the degree that a sentence well below those sentences normally imposed for the offenses was justified in the circumstances. Finally, we have the restraint principle, and this raises the issue as to whether less restrictive sanctions would have been more appropriate for the circumstances. And the rule here, coming from subsection 718.2, saying that an offender should not be deprived of liberty if less restrictive sanctions may be appropriate in the circumstances, and that all available sanctions other than imprisonment that are reasonable in the circumstances and consistent with the harm done to victims or to the community should be considered for all offenders, with particular attention to the circumstances of aboriginal offenders. And from the Gladue case, the restraint principle operates both when deciding whether incarceration is an appropriate disposition, and if it is, when fixing the length of that incarceration. Also from Gladue, they are intended to remedy the acknowledged overuse of incarceration as a criminal sanction in Canada. And then finally, both provisions are remedial in nature and apply to all offenders. From Gladue. Note that Indigenous offenders were singled out in Section 718.2, subsection E, for two reasons. What amounts to a just sentence from a non-Aboriginal vantage point will not necessarily be seen as a just sentence from the very different historical and cultural vantage point of the Indigenous offender and community from the Gladue case. The requirement of a sentence of imprisonment does not, however, end the operation of the restraint principle. That principle requires the court, if it determines that a sentence of less than 2 years imprisonment would be appropriate, to consider whether the term of imprisonment could be served in the community under a conditional sentence, like probation, from Criminal Code Section 742.1. Two more rules. One, the restraint principle favors conditional sentences over incarceration if a conditional sentence is consistent with the proportionality principle. That's RV, RNS. And finally, a sentence of more than 2 years excludes the possibility of probation, directly from the Criminal Code Section 731. So the analysis here, the courts have interpreted Section 718.2e as signaling Parliament's direction that a different approach should be taken when applying the restraint principle to the sentencing of Indigenous offenders. And this court here, in this case, does not agree that Indigenous offenders and black offenders are equal, and they come to that conclusion for two reasons. Specifically for the purposes of subsection 718.2e, they're not equal for that, for those purposes. So, conclusions here, the sentencing policy falls to be set, first and foremost, by Parliament. Parliament chose to specifically single out one group, the Aboriginal offenders, in the context of the operation of the restraint principle in sentencing, especially as implied to imprisonment, and this is because Aboriginal offenders have been singled out for the purposes of the application of the restraint principle described in Section 718.2e. It does not fall to the court to effectively amend that legislative language to include other identifiable groups. And the rationale offered in Gladue and Ipili for applying the restraint principle differently in respect of Indigenous offenders does not apply to black offenders. Although there can be no doubt that the impact of anti-black racism on a specific offender may mitigate that offender's responsibility for the crime, just as it does with indigenous offenders, there's no basis to conclude that black offenders or black communities share a fundamentally different view of justice or what constitutes a just sentence in any given situation. So the indigenous offender's culture and historical relationship with non-indigenous Canada is truly unique, and that uniqueness explains a very specific and exclusive reference to Aboriginal offenders in Section 718(2)(e). Finally, the courts should admit evidence on sentencing directed at the existence of anti-black racism in the offender's community and the impact of that racism on the offender's background and circumstances. Similarly, in considering the restraint principle, courts should bear in mind well-established over-incarceration of black offenders, particularly young male offenders. Finally, as with indigenous offenders, the discrimination suffered by black offenders and its effect on their background, character, and other circumstances may, in a given case, play a role in fixing the offender's moral responsibility for the crime and or blending the various objectives of sentencing to arrive at appropriate sanction in the circumstances. So the final analysis here, as the trial judge acknowledged, the seriousness of Mr. Morse's crime required a significant term of imprisonment, and the possession of a loaded concealed handgun in a public place, the flight from the police, the disposal of the loaded weapon in a public place, all aggravating factors. In most cases, at the true crime end of the spectrum, a prison sentence will be necessary for a Section 95 offense. In some cases, sentences at or near a maximum reformatory sentence will be appropriate. The moral blameworthiness of Mr. Morse's conduct is mitigated by his mental and physical health issues, as well as his educational and economic disadvantages. All of these factors are influenced by the systemic anti-black racism Mr. Morse has experienced. These factors can only properly be understood for the purposes of determining the appropriate sentences by having regard to that context, again, in personal mitigation factors. Taking into account the mitigating and aggravating factors, we think the trial judge could have imposed a sentence ranging from a sentence at or near the maximum reformatory term to a penitentiary sentence of 3 years. When the appropriate sentencing range includes sentences at or below the 2-year mark, a sentencing judge must give careful consideration to the imposition of a conditional sentence. As outlined earlier, conditional sentences properly used can ameliorate or balance or hedge the long-standing problem of the over-incarceration of young black men. Mr. Morse was in custody on other charges when sentenced on these charges. Understandably, given the positions of the parties, no one suggested Mr. Morse should receive a conditional sentence. We would observe, however, that all other factors being equal, had Mr. Morse been before the courts exclusively on these charges and had a conditional sentence like that ordered in Anderson been available, then the trial judge would have had to give that option serious consideration. This court also agrees with the trial judge's conclusion that a term of probation was necessary. Probation provided for an extended period of supervision and access to culturally sensitive counseling. Both of those had the potential to further Mr. Morse's rehabilitation and provide added long-term safety for the community. As probation can only be imposed if a period of incarceration is no more than 2 years, the restraint principle favored a sentence of 2 years or less, as referenced in Criminal Code Section 731. So, final conclusion, taking the factors set above into account, this court grants leave to appeal, allow the appeal, and vary the sentence as follows. So for the Section 95 charge, the count 3, they would impose a sentence of 2 years minus 1 day so that probation can be put into place. Mr. Morse would be entitled to credit for pretrial custody on a 1 to 5 to 1 basis, and they would impose probation for 18 months on the term set by the trial judge. And then on his 2 other convictions, they would impose concurrent sentences of 15 months. So, in keeping with the Crown's concession, this is an appropriate case in which to permanently stay the sentence, with the exception of the ancillary orders made by the trial judge on sentencing. Those orders should remain in effect. So, in essence, the Crown convinced this court. Thank you for watching my video. Please do me a big favor and hit that like button and subscribe to get more videos on law school and NCA exam prep.